I'm Jessica Polk of the Current Consulting Group, and I will be conducting today's webinar presentation. If you have any questions for today's presenters, please use the questions section so that we can include that in our Q&A towards the end of the presentation. Today's presentation is brought to you by DISA Global Solutions. DISA Global Solutions is a provider of workplace safety and compliance services with more than 30 years of experience. Every year, DISA helps thousands of companies make more informed staffing decisions by offering a broad array of industry-leading screening and compliance services. With DISA, you can maintain a strong DOT compliance program while keeping your focus on the rest of your business. As part of your comprehensive compliance services, DISA will not only supply you with official regulatory agency policies, but will help you complete and manage them too. Let us know how we can help you with any of the following agency policies and requirements, including Federal Aviation Administration, Federal Motor Carrier Safety Administration, Federal Railroad Administration, Federal Transit Administration, Pipeline and Hazardous Materials Safety Administration, U.S. Department of Homeland Security, and the U.S. Coast Guard. We make sure you have the information and resources you need to conduct your day-to-day business. DISA, along with Current Consulting Group, will be presenting a webinar on medical marijuana in Oklahoma and how it will impact employers in the state. This webinar was originally scheduled for next Wednesday, August 8th at 2 p.m. Eastern Time. And if you've registered for that webinar already and you're on this call, this is an important information for you. That webinar is going to be postponed. The Oklahoma Medical Marijuana Authority is meeting today to begin a review of a second draft and amendment to the emergency rules pertaining to the program. As it stands, the program cannot move forward until a regulatory framework has been put in place. And so as a result, we are going to postpone next week's webinar so that we can ensure that the information you're receiving about Oklahoma legislation and medical marijuana is the most up-to-date and current information. And so we will be sending out an email with updates about when that event will take place. For us today, we are going to continue with our presentation about Vermont legislation. And today with us, we have two speakers. Our first speaker that I'll introduce you is David Eades. David has 20 years of experience of expertise with the drug testing arena. Throughout his career, he has made a difference implementing procedures and streamlining processes. Also with us today is Yvette Farnsworth Baker, who is legal consultant for the Current Consulting Group. Yvette is a licensed attorney in the state of Florida. Yvette regularly consults on state law and federal regulation questions with CCG's clients. Yvette is an expert in drug and alcohol testing case law and regularly speaks at client webinars. And so with that, I am going to turn the microphones over to David to give us some information. And so I will let you take it from there.
Good afternoon. The first thing I want to talk about the agenda. We have a lot of exciting information for you, and I think very informative of the changing things in marijuana, and especially focus today would be the Vermont. We will review the state of marijuana in the United States. We're going to give you a background of marijuana law in Vermont, recent changes to the Vermont marijuana law, changes that could impact employers, overview of the workplace drug testing and medical marijuana in Vermont, and best practices for operating business in a legal marijuana state. First of all, let's look at the map and look at the changes in marijuana in 2018. As we look at the, in the light gray would be the medical marijuana states, and in the blue, which are getting, seems to me every month it looks like they're getting more states, are the recreational marijuana. This is an ever-changing map over the last 2 or 3 years, and I think we're going to keep seeing changes as we go. State law versus federal law. Technically, state statutes legalizing marijuana should be invalid. In recent years, the federal government has chosen not to enforce federal laws when state pass laws legalizing marijuana. If the federal government chose to, it could invalidate all state laws pertaining to recreational and or medicinal marijuana. Even the Americans with Disability Act, ADA, in medical marijuana. The ADA prohibits discrimination based on disability, but it includes a provision that excludes the use of illegal drugs. And federally, marijuana is an illegal drug. Marijuana, while illegal under federal law, is not protected by the ADA. Some states have disability laws. Some of them do not include provisions excluding illegal drug use. Some that exclude illegal drug use do not consider medical marijuana to be illegal. Some state disability laws may protect medical marijuana use through the ADA, although the ADA does not. This issue is still murky. ADA does not protect medical marijuana use, but also does not forbid it, so a state disability law protecting medical marijuana users does not technically violate the ADA. However, the definition of illegal drug in the ADA could cover medical marijuana, as marijuana is considered illegal on the federal level. Sounds a little confusing. One of the things to look at is marijuana statistics. From 2012 to 2013, positive tests for marijuana in the workplace increased 6.2% nationwide. Post-recreational marijuana legalization, marijuana positive drug test results in the workplace increased 20% in Colorado and 23% in Washington. 64% of employers are concerned about an increase to workplace costs due to marijuana legalization. And we talk about municipal use, and the next couple pieces of data kind of explains or describes some of the experiences of users for medical cannabinoids. 60% of medical cannabinoid users experience effects on their central nervous system. 50% of medical cannabinoid users felt sedation post-use. 35% of all medical cannabinoid users report feeling high post-use. Side effects of marijuana include, but are not limited to, dizziness, speech disorders, muscle twitching, numbness, psychiatric issues, euphoria, dysphoria, impaired memory, acute psychosis, attention disturbances, disorientation or confusion, and blurred vision. I'd like to hear, Yvette's going to speak now on the overview of the Vermont marijuana law.
Thank you so much, David, and thank you for all that great information. Good afternoon, everyone. My name is Yvette Farnsworth Baker, and I'm a legal consultant with Current Consulting Group, and I am going to cover Vermont's marijuana law and specifically the newest changes to Vermont's marijuana law. Just as an overview of Vermont's marijuana law, Vermont now has two separate sets of marijuana rules. There's one framework for those who qualify for medical use, and there's an entirely different framework for the general public. The newest changes to Vermont's marijuana laws really have very little effect on medical marijuana in Vermont. That system essentially remains the same. However, it makes big changes to marijuana laws for the general public in Vermont. So I'm going to give you a little background to the newest marijuana law in Vermont. In January of this year, the Vermont legislature passed the decriminalization law regarding possession and cultivation of small amounts of marijuana. Now, even though this passed in January, the law did not take effect until July of 2018. So even though it passed quite a few months ago, it is newly implemented in Vermont. And we are just starting to see this law take effect and have an effect on people in Vermont. One thing that is very interesting about this law is that it was the first law in the entire country where a legislature decriminalized recreational marijuana. Now, Vermont is not the first recreational marijuana state, as I'm sure we're all aware. However, previous recreational marijuana laws in the United States were all passed by voter initiatives. Now, the difference between something passed by the legislature and something passed by a voter initiative is, with a voter initiative, it is not instituted by elected officials. Citizens in the state decide that they want a law passed that the legislature is maybe unwilling to pass, maybe not interested in tackling. And so a group of citizens gets together, writes a law, they gather signatures to get that law on a ballot, and then at election time, people in the state can vote as to whether they want that law passed or not, and the citizens themselves vote that law in. This is the first time here in Vermont that a recreational marijuana law was passed by the legislature rather than by the voters. And interestingly enough, I think Vermont was the first state to have a medical marijuana law passed by the legislature rather than the voters as well. Another thing that was interesting about this law is the Vermont legislature who passed this, the elected officials, decided to pass this law just hours after the U.S. Attorney General Jeff Sessions made an announcement that the federal government would not have a policy of protecting legal recreational marijuana in the state. For many years, the federal government had a specific policy that said if a state passes recreational marijuana laws and people or organizations are operating in compliance with the state law, the federal government will not be involved. The federal government will not prosecute or enforce federal law in those states. The current administration has done away with that specific policy. We have not seen federal enforcement of marijuana laws yet in states where it is legal. However, the federal government did announce that those protections would be removed. Just hours after that announcement, the Vermont legislature decided to go forward with this recreational marijuana law. So let me cover some of the details of Vermont's new marijuana law. It applies to all adults in Vermont ages 21 and older. And it says that adults 21 and older are allowed to possess 1 ounce of marijuana legally. Adults 21 and older may also grow marijuana. 2 mature plants and 4 immature plants are permitted per housing unit. Now, the possession limits are per individual. The cultivation laws, the cultivation limits are per housing unit. Now, marijuana, in addition to the possession limits, however, marijuana harvested from homegrown plants doesn't apply to those possession limits, as long as it is stored on site, indoors, with efforts towards preventing unauthorized access. So any marijuana that is homegrown with these 2 mature plants, 4 immature plants, any amount of that marijuana can be possessed in addition to 1 ounce, as long as it follows these regulations on site, indoors, with efforts towards preventing unauthorized access. Now, with the new Vermont marijuana law, landlords are specifically allowed to prohibit marijuana use or possession on their property as part of a lease agreement. Also, part of this law is that marijuana cannot be consumed in public. It can only be used in individual dwellings. Impaired driving remains illegal, and distributing marijuana to persons under 21 is illegal. Possessing marijuana, of course, over legal limits is illegal, and using marijuana in a vehicle with a child is illegal. Another interesting thing about this law is that it applies to all people who are within the state of Vermont. It does not just apply to residents of Vermont. It could apply to visitors, people who are not United States citizens, people who are not residents or citizens of Vermont. Anyone within the boundaries of Vermont receives the benefits to this law. Now, another interesting thing about this law is that it is silent on buying and selling marijuana, while possession and certain cultivation of marijuana is legal. Selling marijuana is not legal. There already exist marijuana dispensaries in the state of Vermont for medical marijuana. However, this law does not change the rules and regulations around those dispensaries. Those dispensaries are still only permitted to dispense and sell marijuana in accordance with the medical marijuana law. They are not permitted to sell marijuana for recreational use. And individuals are not authorized to sell marijuana for recreational use. All sale of marijuana in Vermont remains illegal. So let's cover what this law means for the workplace, what it says about marijuana in the workplace, what it doesn't say, and what we can take away from this about any changes to marijuana in the workplace. Now, what the law specifically says is that an employer can prohibit marijuana use at work. An employer can prohibit marijuana possession at work. An employer can prohibit marijuana transfer, marijuana display, marijuana transport at work. Of course, marijuana sale at work, that's going to remain illegal everywhere. An employer can prohibit marijuana cultivation at work. That is what the law specifically states. Now, the new recreational marijuana law does not specifically mention whether or not an employee can prohibit off-duty marijuana use. It does not specifically mention drug testing for employees for marijuana. It does not specifically mention disciplining employees for off-duty marijuana use. However, let's look at what it does say about the workplace. It says nothing in the law will create a cause of action against an employer that discharges an employee for violating a policy that restricts or prohibits the use of marijuana use by employees. Now that is a very dense paragraph, or one sentence, I think, that's full of legalese. So let me break it down for you. I'm going to stay on this screen so that I can see the specific language. Nothing in this law will create a cause of action against an employer. Now, a cause of action against an employer generally means a lawsuit. You cannot sue an employer. It can mean another form of judicial or administrative redress, maybe through the Unemployment Compensation Board or some other judicial entity. But for simplicity's sake, we can think of a cause of action as a lawsuit. So it says that nothing in this law will allow a lawsuit against an employer that discharges an employee for violating a policy that restricts or prohibits the use of marijuana by employees. So Vermont law has always permitted employers to prohibit off-duty recreational marijuana use. Employers have always been allowed to drug test for marijuana use and to discipline recreational marijuana users under certain circumstances. We'll talk about that later. Now, the new law does not change this. This new law does not create a way for an employee to sue an employer for disciplining them or for terminating their employment based on violating a marijuana policy. So this law does not mean that an employee can sue an employer for workplace discipline based on recreational marijuana use. As long as the employer is following Vermont's drug testing statute, following the regulations that allow employers to drug test for marijuana, as long as they're in compliance with that law, this recreational marijuana law does not mean that an employee can now sue their employer for terminating their employment. And to further clarify things, Vermont's State Assistant Attorney General, her name is Emily Adams, she made this statement: Vermont's existing drug testing laws allow testing for federally regulated Schedule I substances. Now, marijuana is a federally regulated Schedule I substance, and she made this statement after this new recreational marijuana law passed. So her response was, Vermont's existing drug testing laws allow testing for marijuana, essentially, for federally regulated Schedule I substances, of which marijuana is one. Her office also released a statement which in part said, Although most employers do not have policies addressing what employees do outside the workplace, especially what they do in the privacy of their own homes, the new law makes clear that if an employer did have a zero tolerance policy for marijuana use, both on and off the clock, an employee fired for violating that policy could not use Act 86, which is this recreational marijuana law, as a basis for suing that employer. So again, this is all a little dense and a little bit legal, but what the law says and also what the Attorney General's office in Vermont has said is that an employee cannot sue an employer based on this new law. The employer still has to comply with all other laws surrounding marijuana, surrounding drug testing in Vermont, but this new law does not change an employer's obligations in drug testing and in disciplining, firing, retaining employees. Now, if you're interested in what the Vermont Attorney General's office has said on this, they released an entire packet online that addresses the new recreational marijuana law, that addresses medical marijuana law, and that addresses drug testing in the state of Vermont following the passage of this law. So they released a packet to try and clarify this law for employers, and it's an interesting read. It's very easy to find on the internet. So let's talk a little bit about what Vermont's drug testing laws are, because they are pretty relevant when we're thinking about drug testing for recreational marijuana. Now, Vermont has what we call a mandatory law, meaning that all employers who drug test must follow this regulation. Pre-employment testing of job applicants can be conducted, but it has to be after an offer has already been, after a job has already been offered to an applicant. So an applicant applies, interviews, whatever the process is offered a job position contingent on passing a drug test. A drug test cannot be conducted before they are made an offer. Now, testing of employees can only occur when there is probable cause to believe that the employee is using or under the influence of drugs at work. So the only drug testing of employees that can be done in Vermont is what we call, here it's called probable cause. In other states, we call it reasonable suspicion testing. This means that random drug testing or periodic drug testing of all employees is not permitted in Vermont. It can only be based on suspicion or cause. As well in Vermont, if an employee tests positive for marijuana or any other substance for the first time, that employee has to be referred to a rehabilitation program. An employee who tests positive for the first time cannot be fired automatically. They have to be offered a rehabilitation program and given an opportunity to complete rehabilitation successfully and return to their job. They can be put on unpaid leave during that time, but their employment cannot be terminated for first-time positive. This applies to marijuana or other drugs as well, I believe alcohol as well. So that's important to remember when we talk about firing an employee for testing positive for recreational marijuana. You do need to remember that first-time positives must be permitted to attend a rehabilitation program and successfully complete it and come back to their job. Now, this list is not exhaustive. These are just some points that I wanted to bring up while we are discussing this. Vermont is extensive. The Vermont drug testing laws are extensive and detailed and really need to be consulted. But I did want to bring up those points because they're relevant as we think about drug testing in the workplace and testing for recreational marijuana use in the workplace. I'd also like to talk a little bit about Vermont's medical marijuana law. I believe that's relevant as well. Vermont's medical marijuana law was passed in 2004, again by the state legislature. Like I mentioned earlier, it was not passed by a voter initiative. For those who are interested in using marijuana medically in the state of Vermont, they have to apply to the Vermont Department of Public Safety in order to become a registered patient or registered caregiver. Now, the requirement is that a person must have a debilitating medical condition. The conditions that are listed in the law are cancer, multiple sclerosis, HIV, AIDS, glaucoma, Crohn's disease, Parkinson's disease, or PTSD. PTSD is not across the board. There are certain requirements that a patient has to meet for using medical marijuana for PTSD. As well, though, if an individual has a condition not listed, they may qualify for medical marijuana use if their condition is chronic, debilitating, and at least one of the following symptoms are present: wasting syndrome, chronic pain, severe nausea, or seizures. So other conditions that are not listed can qualify a person for using medical marijuana in Vermont, but they have to meet these requirements that I just listed. Under Vermont's medical marijuana law, medical marijuana use can be prohibited in the workplace. We always need to remember when we say use can be prohibited in the workplace, that has a specific meaning of actually using marijuana while you are at work or while you are working. Employees can be prohibited from working under the influence of marijuana. Medical marijuana patients are not exempted from prosecution for driving while under the influence of marijuana, for being under the influence while they are in the workplace or in a place of employment, and they are not exempted from prosecution for operating heavy machinery or handling a dangerous instrumentality while under the influence of marijuana. It's also important, as we're talking about marijuana in the workplace in Vermont, to talk about disability law. Now, earlier on, we mentioned the ADA, the Federal Americans with Disabilities Act, and how disability discrimination under the ADA does not cover medical marijuana use because medical marijuana is an illegal drug under federal law. While that is true, Vermont has its own state law that also covers disability discrimination, and it is slightly different from the Americans with Disabilities Act. Vermont's law is called Vermont's Fair Employment Practices Act, VFEPA. I'm not sure that acronym is much more helpful than saying the full name. Under Vermont's disability discrimination law, it is unlawful for an employer to discriminate against a qualified individual with a disability. But like the ADA, this law does not just prohibit overt discrimination, but also requires employers to provide reasonable accommodations for disabilities. Now, when we talk about disabilities, both under the ADA and under Vermont state law, we have to remember that the definition of disability is very broad. It's not necessarily what you think of as a disabled person, a person in a wheelchair or who cannot see. A disability can be more broad than that. It can be a person overcoming a substance abuse problem. It, in certain circumstances, can be a person with chronic pain. Now, under Vermont's Fair Employment Practices Act, a person who uses medical marijuana for a qualified disability is subject to reasonable accommodations in the workplace, in their workplace policy. So for individuals in Vermont who have a qualified disability under the Fair Employment Practices Act, who use medical marijuana to treat their disability, they may require a reasonable accommodation in the workplace policy for that medical marijuana use. Under the VFEPA, employees' current illegal drug use does not disqualify the employee from protection. Oh, I'm sorry. Under the VFEPA, in general, an employee's current illegal drug use does not disqualify them for protection unless that use is going to prevent them from performing the duties of their job, or if that use constitutes a direct threat to the property and safety of others. So those are ways, it's very complicated. I mean, we could spend not just a 1-hour webinar, but probably a 3-hour webinar talking about disability law and medical marijuana and what constitutes a direct threat to the property and safety of others, or what constitutes, a person being prevented from performing the duties of their job because of their medical marijuana use. I just wanted to bring that up to make sure that you're aware, because while it is true that the new recreational marijuana law does not create a cause of action, employees cannot sue their employers for disciplining them based on recreational marijuana use as long as the employer has been following Vermont's drug testing statute. It is possible that a medical marijuana patient could sue their employer under the VFEPA, under Vermont's disability discrimination law, if their medical marijuana use was for a qualified disability, if they met the requirements of the statute and whatnot. So it's very important to remember that medical marijuana use is different than recreational marijuana use in Vermont. Even though the new law only applies to recreational use, it does not touch medical marijuana use. We always need to remember that marijuana use is a much trickier situation because of Vermont's disability discrimination laws. So let's cover some best practices when operating in the state of Vermont. It is absolutely essential to have a very clear written policy that employees understand. If an employer wants to prohibit off-site recreational marijuana use, that is absolutely permitted. However, you need to be clear with the employees that not just on-site use is prohibited, but off-site use is prohibited as well. Employees need to be clear that working under the influence of marijuana, whether that's recreational or medical, is prohibited, absolutely. Employees need to be aware that possession at work, again, of any type, recreational or medical, is prohibited. And that needs to be clear to all employees. It really needs to be in a written policy. Best practices are going to include pre-employment and probable cause testing in compliance with Vermont laws. Again, what I covered today is not an exhaustive list of marijuana's drug testing requirements. So if you're unclear, be sure that you are consulting with drug testing experts or with an attorney to know what all the requirements are for Vermont drug testing laws. But the best practices will include pre-employment and probable cause testing. Best practices also need to include reasonable accommodations for disabled individuals who are using marijuana medically and in compliance with Vermont's medical laws. I'm going to turn my time back over to DISA to talk about some practical experience and how to best apply this when operating in Vermont.
Okay, thank you. Yeah, the first thing I wanted to mention, and it's not on this slide, but just remind everybody that this does not change the way your federal testing is done. If you're doing DOT testing, we want to continue to do random. We want to continue to do return to duty, reasonable suspicion, and all the things required by the different federal DOT programs. This is for Vermont only, but not cover. It does not cover federal testing. You know, the first thing on practical experience on any state, just not Vermont, but any recreational state that they're using marijuana recreational, is your employees have to understand your policy, and it has to be very clear to them. For the employees, this is new also. You know, what can I do? Oh, now I can use marijuana and it's legal. You know, they need to know what your policy is and what you can do and what discipline that you will use to protect your employees and your business interests. Very important that they understand the policy. And it wouldn't be bad to you know, training on the policy or understand, making questions, and also to maybe hand out some information about marijuana and some of the risks and things with marijuana, so they get a better idea of what's going on there. Second thing to protect you, your supervisors and management must be trained in the signs and symptoms of use of marijuana and the behavioral changes. And this is not only, you know, somebody coming in and they're disoriented and that, but it could be somewhat long-term changes that you're seeing over time. That they're coming in, they're not working they're not as alert as usual. They have other behavioral change. It's not them. And so your supervisors and your management team need to be on their game of identifying these signs and symptoms and these behavioral changes. Because if you do test for reasonable suspicion, what you put down as signs and you recognize the symptoms and behavior changes are going to protect you and make your positive test go right along as strong evidence for the use of marijuana in the workplace. One of the things we're seeing with states that have legal recreational use, as you would know, we have higher positive rates. There's more frequent use than they had before. And we're also seeing in states, we're seeing higher accident rates as far as driving and things like that are concerned also. Here's what you're going to kind of look forward to in the recreational states, the latest ones we've seen. The marijuana positive rates have risen sharply. As you can see, Nevada, 43%, 14% in Massachusetts, and 11% in California. We will see a rise in Vermont. That's what it's telling us. It's just kind of saying, hey, this is the future of what we're going to see. So we really need to protect ourselves using, as I say, good, clear policies, having our employees know the policies, and having our management and supervisor staff being able to recognize the symptoms and behaviors of somebody under drugs, under the effects of drugs. I'd like to turn it over to Jessica for some questions and go forward.
Absolutely. Thank you so much, David. And Yvette, these questions that we've received as they've come in, we'd like to go ahead and send them out to you. And so I would, either of you are welcome to answer the questions, but I think this first question probably goes back to Yvette. And the question is, what is probable cause to drug test?
Thanks, Jessica. And that's a great question. Probable cause is a legal term. We see it in various different areas of the law, but it basically means there are facts to support your suspicion. Now, the Vermont State Attorney's Office has said that probable cause is a slightly higher standard than reasonable suspicion. Reasonable suspicion is a little easier term to understand. You have reason to suspect, and even under reasonable suspicion, it has to be based on facts. It can't be based on a hunch or a feeling, or I think this person might be using drugs, but you can't necessarily list out any reasons why you believe that. Both reasonable suspicion and probable cause require some facts to back up your belief, why you think that. And I said that the Vermont Attorney General has said that probable cause is a slightly higher standard than reasonable suspicion. That just means you need maybe just a little bit more evidence to back up your belief before you're permitted to drug test an employee in Vermont. So again, like David said, make sure that supervisors and employees are trained to recognize the signs and are able to document the basis for their belief that an employee may be under the influence, may be using drugs in the workplace. And if you have facts to justify those beliefs or those suspicions, that will constitute probable cause. But make sure it's the best practice to make sure that those are documented and that you would be able to offer up the reasons behind that if you needed to in the future, instead of just scrambling for something like, well, I just thought that maybe they were, I just had that belief. Make sure that those facts and those reasons get documented to support your probable cause.
Okay, excellent. Another question that we have is, can an employer refuse to hire someone for testing positive for marijuana? And this question could go out to either. Yeah. Go ahead,
yes, I can jump in with that as well. As long as the employer is following Vermont's requirements, I covered some of them before, but I can cover a little bit more. If someone's applying for a job, they need to have some written notice that you're going to drug test and make employment decisions based on that. And then, like I said before, the employer needs to make an offer to the employee prior to drug testing. So, and there are the drug testing has to comply with the statutes and with the statute in terms of it needs to be at a certified laboratory and be the procedure of the drug testing has to go a certain way. But as long as the employer is following those requirements, if they have an applicant who tests positive for marijuana, they can refuse to hire that employee on that basis. The only caveat I'm going to add in here is, again, when we talked about disability law, if the person is claiming a disability and requesting an accommodation and using medical marijuana in compliance with Vermont medical marijuana law, that could be a trickier issue, and HR would definitely need to get involved there. But for recreational marijuana, absolutely 100%. If you're following the right procedures, the person tests positive for recreational marijuana use, you can refuse to hire the person on that basis.
Okay. What about drug testing employees who are involved in workplace accidents? How would this impact that?
Well, that requirement, that's not going to change the requirement of probable cause, unfortunately. Employees can be drug tested following a workplace accident, but you still are going to have probable cause to suspect that the employees you're testing were using marijuana or another drug at work, or were under the influence of marijuana or another drug at work in order to test post-accident. Just again, need to document the reasons why you suspect there might be drug use at play. Make sure you're only testing employees who you have probable cause for. There might be probable cause that, say, the driver was using marijuana, but that's not going to necessarily apply to everyone involved. There's still going to have to be probable cause for everyone you drug test post-accident. But if you can lay out your reasoning, the facts that lead you to suspect that marijuana use, drug use was at play, then you can test employees following a workplace accident.
Okay, great. Information and very helpful. I have a question about if you're a Texas-based company and you have employees in Vermont, how would you respond to that situation?
Yeah, this is Dave Eades. They have to follow Vermont's law if they're working in Vermont and they're tested in Vermont. I would think they would have to follow that law.
Okay.
Vermont law.
Yeah.
As you said, Yvette was talking about, and I think on one slide she talked about even visitors are covered by the law.
Okay.
But certainly, if you're a company, even though you're a company and they're tested, you know, and they're working in Vermont, being tested there, they would be covered by Vermont. Yvette, do you agree with that?
I do. Yeah, I agree 100%. We've been seeing, I've been working on even European Union law, and U.S. companies that are operating in Europe are suddenly subject to following Europe's laws. So if you're a company that has employees in different states, you absolutely need to be sure that the employees in every state are subject to the laws of that state where they are present.
Another question that was responding to if your employees are hired in Vermont but are working in other states.
Where they're present, where their bodies are is what law is going to apply to those employees.
Okay, good information. Thank you for those thoughts and that clarification. Another question that comes up a lot, and it's coming up today in this presentation as well, is the issue of whether or not marijuana should be removed from their drug testing panel in their policy. What would you advise a client if this was their situation?
This is Dave Eades. I would not advise removing marijuana from their policy. You want to do everything you can to protect your workplace and the other employees. And I think the use of marijuana at the workplace could certainly be a safety issue. And I think it's a responsibility of the employer to keep the whole workplace safe, and taking marijuana off the panel is not the answer.
Okay.
Yeah, I agree. Even from a legal liability standard, I don't think that simply refusing to test for marijuana is suddenly going to make you safe from any liabilities. You always have an obligation to ensure that you have a safe workplace for your employees, for your customers, and if you are not taking steps to protect clients, customers, other employees from safety hazards, you're running the risk not only just morally and for the sake of having a good workplace, but legally I think you're vulnerable to legal liabilities if accidents happen and you've done nothing to ensure that you have a safe workplace, especially when we're looking at these rates of how marijuana use increases so much when recreational marijuana is legalized in a state. I think you're really putting your workplace at a safety risk and yourself in a risk, like a liability risk that way.
Thank you so much for your answers. We're getting really close to the end of this webinar presentation, and I wanted to do a little bit of housekeeping before people jump off, because I know people like to jump off at the end. So before you go, I just wanted to make sure that everyone on the call knows that today's presentation has been recorded, and we will be sending you out a link to access that recording so you can review this information again. You can share it with your colleagues if you know people who weren't on today's webinar presentation but would really benefit from knowing more about the changes in Vermont legislation, then please send this information on to them when you get that information of how to access the recording. Of course, you can reply to the email that you got about registration. You can contact DISA Global Solutions at transportationsales@disa.com, or also we invite you to, if you're a DISA client, to reach out to your representatives at compliance@disa.com. Of course, if you think of any questions after today's presentation that you would like clarified again, reach out to compliance@disa.com. We also wanted to make sure that everyone is aware that there is an opportunity for continuing education credits if you email credit@currentconsultinggroup.com. And so then as we are finishing up, the last thing I wanted to remind you all about is that August 8th webinar presentation about Oklahoma is being postponed. I mentioned that at the very beginning, but if any of you joined us later in the call and you are anticipating the webinar next week, which was about Oklahoma medical marijuana legislation, that meeting is being postponed, and for very good reason. The Oklahoma Medical Marijuana Authority is meeting today to begin review of a second draft and amendments to the emergency rules pertaining to the program. So as it stands, the program cannot move forward until a regulatory framework has been put in place. And so we want to postpone this webinar so that we make sure that we are bringing you the most current and up-to-date information. So we will send you updates about that. But if you are already pre-registered for the Oklahoma webinar, then when we change the date, you will just get an email update that says the date has changed and you can stay registered. You don't have to worry about whether or not you'd have to register again. But if you have not registered for the Oklahoma webinar and you are interested in that information, we will be sending out the link for that registration as well. We thank DISA Global Solutions for hosting this presentation. We hope that you have found this information informative and helpful, and we look forward to having you join us again, hopefully for the Oklahoma webinar, but for other DISA webinars in the future. Thank you, and this does conclude today's webinar presentation.